call People versus Snyder.
Good afternoon, and may it please the court. Sofia Nelson of the State Appellate Defender's Office on behalf of David Snyder. I will attempt to reserve a few minutes for rebuttal. My sister counsel touched on the fact that in Earl, this court adopted the Kennedy-Mendoza-Martinez test, the intent effects test, when examining ex post facto challenges. That is a multi-factor balancing test. One not need to find that every factor in that test weighs in Mr. Snyder's favor in order to determine that SORA is punitive in a cumulative totality analysis. And she pointed to several states that in fact have found there's a rational relationship to a non-punitive purpose, and yet still found those states' registries to be punitive. I would add to that a federal district court in Colorado, a state without geographic exclusion zones, in Millard versus Ratkin, found that state's registry to be punitive, even though the court found a rational relationship to a non-punitive purpose. What happened to Mr. Snyder is emblematic of how the effects of SORA are punitive. He was able to secure employment despite his felony convictions, but upon learning of his status on the registry, he was immediately terminated. His failure to comply with extremely onerous immediate in-person reporting requirements resulted in his incarceration. At this time, I'll waive the remainder of my free fire zone and welcome any of the court's questions.
Counsel, do you have the same, if we find some aspects of the statute are punishment, but not the reporting requirements, does your client have any avenue for relief?
The question is, are the portions that this court were deemed punitive, would they be severable?
Yeah.
If the court could successfully sever portions and what remained was a functioning statute, and that functioning statute still criminalized the behavior of Mr. Snyder, then yes, he would be out of luck. It is my position that the punitive portions of the 2011 amendments are not severable, and therefore the entire statute needs to be struck down for retroactive application, and that all 2011 people who were convicted pre-2011 would need to be removed from the registry. And to go to the revival argument that is advanced by the prosecutor, Michigan has explicitly adopted an anti-revival statute, MCL 8.4, and this, while may not, it explicitly applies to legislative repeal, and whether judicial repeal would be covered by the statute is a question we would, again, welcome briefing on if this court were to grant leave and we could brief the severability question. But it certainly demonstrates a strong preference against revival. And I think the main problem with revival here is something brought up by Justice Viviano earlier this morning, which is notice, which is incredibly important in the criminal context. What are we reviving and to whom are we reviving it? You can't find a pre-2011 amendment SORA on the internet. What statute applies and to whom? Are we also getting rid of the good changes that have happened to the sex offender registry? The fact that Romeo and Juliet offenders have been removed, juveniles under the age of 14 have been removed, certain offenses have been removed. Is that going to go away too because we're reviving is that what the legislature would even want? I think if this court were to engage in revival, that would be quintessentially legislative activity that's inappropriate. And that the best solution here, if in fact the court finds that the punitive portions of the statute are not severable, is to just strike the 2011 version for retroactive application and leave it to the legislature to decide whether it wants two registries, one for retroactive application and a separate one for prospective application, because obviously the issue here has nothing to do with prospectively applying this registry. Or if it wants one registry for everyone, that would not be deemed punitive and therefore not be a problem. I want to discuss in-person reporting. Smith v. Doe, I actually recently listened to the oral arguments in that case, and that question came up a lot. Is there any in-person reporting? And at least the people defending the statute were arguing that the initial registration in Alaska was in person. But after that, all that was required was an annual mail registration by mail. A form was sent, the registrant would fill out the form and mail it in. Now, whether annual in-person reporting alone would be punishment, I don't know that we would be here today if that's all that SORA required. Maybe even if it was only biannually. But what's required here is immediate in-person reporting upon any number of normal life events. If Mr. Snyder wants to buy something and he goes to Meijer and it's not there, so he decides to buy it online and he needs to open an Amazon account, he better get to the police within 3 days immediately or he's going to be arrested. And what happened to him here is emblematic of that. He had that job for 2.5 days before the police showed up at his place of employment to check on his SORA compliance, which resulted in his immediate termination. So the purpose of the immediate in-person reporting requirements, to give the police information about where you work, had already been achieved. The Michigan State police officer showed up, found out he was working there, found out that his showing up got him fired. The purpose is gone. They wait. He doesn't report. They arrest him. They prosecute him. He goes to prison. That type of immediate in-person reporting, I think, under the Kennedy test, is in fact punitive, and that's exactly what states in Maine, Pennsylvania, New Hampshire found, the state Supreme Courts. There's no geographic exclusion zones in those states, and yet, under the Kennedy test, it was still found to be punitive. Now, I also want to address this research issue. Now, I don't think it's necessary for this court to find that there's no rational relationship to a non-punitive purpose in order to deem SORA punishment. But I believe the Sixth Circuit's analysis was correct. There's two areas of research that I often think get conflated. One is, what is the recidivism rate for people who commit sex offenses? And while there are studies that vary at what that rate is, there is general consensus on a few points. The study relied on in Smith v. Doe was completely erroneous. We can trace back that there's an article in the appendix, not true. It wasn't a study. People convicted of sex offenses are a heterogeneous group whose risks vary. I don't think there's any dispute on that point in the research. And even the Department of Justice says that actuarial risk assessments are far superior measures of the risk an individual registrant poses than their offense of conviction. And another area of consensus is that risk decreases with time offense-free in the community. The threshold for even the highest risk offenders is 17 years. If you desist for 17 years without committing a new sex offense, your risk of reoffending falls below the base rate of the risk in the general population. So lifetime registration bears no rational relationship to a non-punitive purpose, nor does 25 years. The second area of research is, do the types of restraints and disabilities and monitoring placed on registrants by SORA advance public safety? Do registrations actually protect the public? And there's no study that the prosecution points to say that registries work. We point to some studies that show that the incredibly burdensome types of registries at issue here in Michigan actually increase recidivism by making it more difficult for registrants to have stable housing, to find employment, and to maintain family connection. Absent any evidence that registries work, I don't see a rational relationship to a non-punitive purpose. And the registry is premised on two false assumptions. One, that all sex offenders are the same and they're all going to reoffend at frightening high rates. And two, stranger danger. When we know that over 90% of children who are the victims of sex crimes, those crimes are committed by people they know, not by random strangers who snatch them from a park. Now, it's not that those things don't happen, of course, but the vast majority, that's not how it occurs. I also want to talk about the internet and the ways in which, even if geographic exclusion zones weren't at issue here, even if we didn't have mandatory immediate in-person reporting, that SORA might be punishment. And I would turn the court's attention to Packingham v. North Carolina, a recent United States Supreme Court decision involving sex offenders, where it's a First Amendment case, but in that case, the U.S. Supreme Court said that the internet is citizens' main source of information in our current age, and that the internet has become the modern public square. The dissemination of what at the time was accurate information at issue in Smith v. Doe, simply the fact that someone had been convicted of a sex offense, on the internet was something entirely different in the year 2004 than it is today in 2019. And we add on top of that Michigan isn't just publicizing the fact that Mr. Snyder was convicted of the lowest level of criminal sexual conduct back in 1994. They're labeling him, they're branding him. And I think that goes directly to what my sister counsel quoted in D. Piazza. They're saying he's a tier 2 offender. It implies, and I think any member of the public on the registry would assume, that some assessment's been made, that this man is presently dangerous. Those tier notifications are on the public website, right next to under his picture where it says, submit a tip. An anonymous tip, by the way, that deputizes the Michigan State Police to respond to it within 7 days. By putting this information on the modern public square, branding people as dangerous, SORA essentially deputizes the general public to monitor offenders for compliance with a number of incredibly onerous reporting requirements. And so even if the person's not in violation, an anonymous tip can lead to a Michigan State police officer going to that person's place of employment, going to that person's home, going to that person's school. What do you think the effects of that are going to be? Well, we know in Mr. Snyder's case it meant that a place that was comfortable hiring him fired him. And I will reserve the remainder of my time for rebuttal. Thank you, Your Honors.
Thank you, Counsel.
Good afternoon. May it please the Court. Eric Christusha from the Attorney General's Office, appearing on behalf of the Gratiot County Prosecutor. With me at the appellee's table, in addition to Mr. Justian, is Catherine Dalzell, Assistant Solicitor General from the Department of Attorney General. And I think we should complete all the introductions because Miriam Aukerman is also at appellee's table for the ACLU, so we're all seated here for you. I have 3 points I'd like to make. The first is, I think there are good arguments that Michigan's SORA statute is constitutional, that the Sixth Circuit is an outlier. I think there's also some good arguments that if this court didn't agree that there's a path for severing the portions of the statute that would be, that could be removed consistent with the legislative intent and consistent with Michigan compiled laws 8.5. But the third point is probably the most significant, I think, given the posture of this case, and that was the invitation or the suggestion from the ACLU that this court should allow there to be a legislative action taken. And I think that is the right answer. I think a little bit differently about this than does the ACLU in its recommendation. I think this court should grant leave, set it for argument for October, and then see what happens with this legislative opportunity. And the reason I say that is this, that if this court did agree with the argument that the statute is perfectly constitutional, it would then create a conflict with the Sixth Circuit. And I think the State Appellate Defender's Office would be duty-bound to file a petition for certiorari because, frankly, these orders in this case precede the federal decisions. So I think insofar as there's collateral estoppel, I think it would run in favor of the state court decisions. So I think they'd be bound to file petitions for certiorari. And it may create a conflict, and then the United States Supreme Court may take the case. In our federal case, we filed our petition for certiorari, and from the Sixth Circuit decision. The court asked for the opinions of the United States Solicitor General. They said, don't take the case, and they didn't take the case. This may force the court's hand. But even if that happened, and let's say the United States Supreme Court found the statute entirely constitutional, we know in the federal litigation that the federal district court in 2015, Judge Cleland, he found significant portions were subject to vagueness and enjoined them. So even if we won a year from now everything, we're back in litigation for 3 or 4 or 5 more years. I mean, this litigation has been in place since 2012. There has been uncertainty for 7 years, and the idea of creating uncertainty for another 3 or 4 years is, I think, in terms of governance, not what I would want to see. I mean, I have arguments about why I think this is constitutional. I'd be willing to make all those arguments, but frankly, I think what's happened in the federal litigation is the court has indulged the parties to see if there can be a legislative action taken. In fact, I was in a meeting with Ms. Aukerman, and we were before the Michigan State Police and representatives from the legislature and talking about what actions can be taken, because frankly, I think for the people of Michigan, there is a need for there to be a statute that's not partially enjoined, and what does that mean for the Michigan State Police, and what kind of notice does that provide for defendants? I have all my arguments about why we should win, and in fact, if you disagree with that about what this court could do, but I think the court's time is probably better spent granting a full application, because I was even thinking about this 15 minutes. If we wanted to talk about everything, this probably is one of those cases that has lots of places which the court could ask lots of questions if it wants to delve deep into constitutionality, and also if it is inclined to find it unconstitutional. I think the severance questions are rich, very interesting ones. I don't think there's been adequate briefing. I agree with the representation from the State Appellate Defender's Office as well. In fact, in kind of preparing for this, I found the case from the Michigan Supreme Court that allows statutes to be revived. I mean, the rule of law for Michigan is that something that's constitutionally void, that repealed the repeal itself would be voided and the original statute would be in place. I don't think it's necessary, frankly, because the legislative analysis here was clear that they were trying in 2011 to make the Michigan statute SORA compliant, and the United States Solicitor General kind of lays it out nicely about the ways in which Michigan statute goes beyond that. So if you were in a position to think the Michigan statute was unconstitutional, it wouldn't be very hard to identify. Not all of 2011 would go down. It would be just portions of 2011 amendments. And all of the federal appellate courts have found the SORA statute constitutional. So where that comes, though, in terms of practicality, the one point of important disagreement I have with the ACLU brief is on the question of collateral estoppel. Now, that hasn't been raised, and arguably it's waived if not raised. But the state court orders here are first in time. The state trial court orders are from 14 and 15. The Michigan Court of Appeals decisions here are from February of 2016 and from before that, in the best case. The adverse federal appellate decisions from August of 2016. Now, in my reading of the Michigan rules on collateral estoppel, I mean, there's kind of some conflicting case law about whether a final judgment that's subject to appeal is given preclusive effect. The federal rule is that it is. So you can have a federal district court judgment, it's pending in the Sixth Circuit, that decision from the district court's given full preclusive effect. Well, there is a decision from this court suggesting that would be the same answer. Michigan Court of Appeals has said to the contrary and published decisions saying it has to be exhausted on appeal. I think if litigated here, this court would conclude that. And the reason that's relevant is that the state court decisions were first in time. So in other words, the suggestion that this case should be remanded back to preclude the state from pushing forward these claims, it's not well taken. I think that the better course is to set this for argument. In fact, if you thought the collateral estoppel...
Mr. Sushai, I understood the proposal to be remanded for the trial court to consider the legal question you raised, which I think I agree with you is a somewhat open question. So let the trial court sort out the collateral estoppel question.
Well, and there would be another question, because if it is a federal, because of course if it's a federal order that's being vindicated, it's the federal preclusion rules that would apply, and of course that would then enable us to raise the Mendoza defense. But that's all you're right. But the only thing I think that would be lost is this went back to the trial court, is one of the points that was made earlier was that we've been in this position since August of 2016, really not so much. Probably October of 2017. Everyone's known that our petition for certiorari has been denied since October of 2017. We had the full expectation in the Department of Attorney General that the legislature was going to step in And now we are here almost 18 months later with no statute. And the Michigan State Police
So
and
you think
others.
it puts more pressure on the legislature to get it done if we grant than if we remand it? Is that what you're saying?
Exactly. And then if the
So
court.
can I play it out for a second? Just let me.
Sure, please.
So we grant, and we ask for full briefing on whatever, I can think of about 15 questions I'd like full briefing on. But you don't care. You just want, you want it on the October schedule to put pressure on the legislature to fix whatever's going on. But what does that do for Mr. Betts and Mr. Snyder? If, say the legislature fixes it and they write a new statute, and it's a statute that everybody agrees is constitutional, all the lawyers at this table all say, wonderful constitutional statute. Do Mr. Betts and Mr. Snyder get some relief, even if, as you say, the state court's judgment came first? Or do they have a Rooker-Feldman problem? What kind of problem do they have?
Right,
Sorry.
the practical outcome. No, that's a very, I haven't thought of that, and.
I know, but that's what you're here for.
Because I do know this, and talking, because I know both Mr. Betts and Mr. Snyder have fully served their sentences, so that they are out in the community. So but it's not, that's right, isn't it? Oh, he's still in?
My understanding was, at least one of the defendants, the trial judge was, Mr. Betts, the trial judge would not put in prison, was letting him litigate it for here.
Oh, I see.
So he may have to go to
out.
prison for
I
a
know
couple of years.
My mistake is I spoke to my local prosecutor, so Keith Cushing, he kind of updated me on Snyder, Mr. Snyder, so I was aware of his posture, but I wasn't with Mr. Betts. Then, seems to
question,
me,
right? Yeah.
that's right. Well, in a way, the question is this. I mean, this reminds me of what Justice Markman frequently says, is not just deciding one case, you're deciding the next 100 cases, right? So if it comes to pass that the legislature remedied the statute,
Yep.
this would no longer be a jurisprudentially significant issue. That doesn't mean that these defendants would not be entitled to relief if they were entitled to relief. But this court could, if it wanted to take some action in dispositional order, not that I'm conceding anything, right? I'm not saying we should lose in any fashion.
I
but
take your point. A
clean up.
quick order in one case that's not jurisprudentially significant is not something that people are going to worry about. So.
That's right. But I think if it does come to pass that there is no legislative remedy, and this court is in a much better position than was the Sixth Circuit. I mean, think about what the Sixth Circuit did. It said, look at all this, it doesn't pass constitutional muster. Now, I mean, if you try to tease out how many different components of the statute there are, I mean, it's probably different ways you can configure it, but the question's always been left to us. Let's say the legislature came in and reenacted everything but two components, or one component, or one small component. I mean, arguably, it's a new legal question. There was no guidance provided by the Sixth Circuit. This court has 8.5. It has, frankly, it is the final arbiter of Michigan law. It is in a much different position with respect to the statute if we do not come to a position where the legislature has passed the statute. And this is the place, in my view, where the court should resolve. Because one of the themes that the state always insists upon is that the state courts are of equal dignity to the federal courts. And even if we're subject to the 1983 actions for the Michigan State Police and our executive officials, it doesn't affect the question whether this court is bound by the Sixth Circuit. It is not. And in fact, the party plaintiffs of that case have only been 6. Now the class certification has been granted, but the judgment has not been applied to them. This court is still in a position, in fact, it seems to me that that's a critical component, that this court still has the opportunity to fashion a remedy if it thought it were unconstitutional if there is no legislative remedy in a way that the federal courts cannot. Judge Cleland is not in a good position because he is a great judge, but he is not a state judge. He is not someone clothed with the authority to look at state law and to apply 8.5 and to sever in a way that this court can. So it seems to me that the practical decision to grant the application and set this for October call, and even to think about the questions the court would like to ask, because I think that there are many and interesting ones, that would be the better outcome than to just kick this down and expect that there's going to be an outcome because we have been waiting. I didn't expect to be at the podium talking about this. I was part of our conversations back in Telmakoski quite a while ago, and we thought this may be the end of the train because there would be a new statute, and here I am. So it seems to me that I think that would be the prudent course.
I'm taken aback a little bit because it's the first time I ever remember you coming into the court and offering a political solution to anything.
It's not designed to be a political solution.
But let me just play it out. The legislature has enacted in 18 months, and they move slowly in any event. You think setting this for argument in October is going to get them to move? I have the opinion that it'll get them to say, we could take this off the table. The Supreme Court is now committed to this, and they're going to do it.
Well, I think in this is one of the reasons I feel really as a kind of an officer of the court, I feel bound to kind of argue this position as well, because one of the things we have said in federal court is that we are willing to be good faith participants. I can't speak out of both sides of my mouth. I mean, I can't be saying, yes, we'll negotiate. No, we're going to try to do something differently. So I think it's important that we be good faith participants. Judge Cleland has been gracious in allowing the parties because, I'm all about the law. I mean, my thought is I would be more than happy to stand up here and say we should win, and to make all the arguments. In fact, I was getting kind of riled up hearing about the studies again because, I'm kind of an old school guy. My thought is I know about Kurt Hansen. The Department of Corrections is totally dependent on him. He's talking about a recidivism rate of 16%. I know what sex offenses mean, and that's just those ones that were charged or arrested for. 16% of everybody who has reoffended sexually. That is a staggering number. I think it's just the opposite effect, in my view. I'm always ready to talk and defend a Michigan law. So this isn't intended to be a political solution, but the reality of the posture of the case.
Do you have reason to really believe that if we set this for October or even December, that the legislature is going to move?
Oh yeah, I do. I'm committed. We had the guy. I don't want to describe the process. We were sitting there. If the legislature doesn't act, it seems to me it would be a dereliction of duty. And I'm not to be critical of the legislature, but it just seems like
18 months. A bigger dereliction in the past 18 months.
It is incumbent on the legislature to remedy this. It seems to me. And I think to ask this court to go into this thorny question and create a conflict and then to have another decision come down and create a new injunction. I've even kind of truncated my comments since there were no questions asked on the substance. I thought the court is really interested in the process because really this is a need for another solution. It seems to me. I feel bad I didn't come in talking more about the substance, but I realized and kind of preparing and hearing that.
Why is it obligatory upon the legislature to remedy something when the Court of Appeals of this state has said that what they've previously done is constitutional? And why is it a wise thing for this court to punt as part of some judicial choreography, to mix my metaphors, and thus to have the legislature act completely in response to and as a function of what the federal judiciary has done, not the highest court of the state of Michigan?
You are exactly right. I am the biggest proponent of this court being the final decision maker on all constitutional questions that come before state law. I have been a big advocate for us certifying questions and bringing it before this court. But the point at which we are then subject to 1983 damages, we've already told all of our executive officials don't apply this law. The Michigan State Police is not applying the 2006 and 2011 amendments retroactively, and all other state officials and local police officials have been directed to do the same, because if they get sued for 1983 damages, even though this court is not even though this court's not bound by the Sixth Circuit decision, all the federal district courts are. And so if we get sued, there is nothing we can say. We are left without any defense. So we've been checkmated. It's, for me, a very frustrating thing, because the very thing you're talking about happens again and again. We see challenges to the constitutionality of Michigan law filed in federal courts, and where the real authority to make decisions about the meaning of Michigan law is in this court. We are more often than not postured before a federal district judge who I don't think are often as knowledgeable about Michigan law as is this court. So my intention is not to become a political advocate, but at the same time, I do know that we are involved in negotiations before Judge Cleland. He can issue an injunction on us at any time, and the only claim we would have about the people that could be exempted from that injunction would be Mr. Betts and Mr. Snyder. So we would have 44,000 people over here and these two people over there. Other than this court then finding in our favor on the constitutional question, ruling in our favor, and then they would have to file the petition for certiorari. We can't even file the petition. They would have to file it. Let's say their clients didn't file it. It again would have no practical bearing. We would then have to come in and file a collateral challenge to the district court, ask that Judge Cleland set it aside when he's bound to follow the Sixth Circuit, ask the Sixth Circuit to set it aside, and then we have to file a petition from there, which would take 2 years. I am all about asking this court to reach constitutional questions. But we are left without an ability. So I'm willing to make all these arguments. And in fact, if the court says it's our duty, let's reach the constitutional questions, I'm not saying don't do that. I'm just saying this is the reality for us in applying the law.
Thank you, Mr. Restuccia.
Just briefly, I agree with Mr. Restuccia, so I thought I'd come up here and say that. If this court were to grant leave and the legislature didn't act, the court would be in a position to issue an opinion, which is ultimately what Mr. Snyder seeks in this case. Funnily enough, I was in law school and an intern for Miriam Aukerman when Doe v. Snyder was filed. And then I worked with her as a Skadden Fellow on that case. So this has been going on for a long time. And it's simply, I think, untrue that the unconstitutional portions of SORA are not currently being enforced. And on page 6 of my reply brief in footnote 20, I cite to a number of unpublished 2018 Court of Appeals cases involving prosecutions of registrants for violations, some of which I think are covered by the Sixth Circuit opinion. Mr. Snyder and Mr. Betts live in constant fear of being caught doing something against the registry and being hauled off to prison again.
Is it true that your client has served his time?
Yes, my client has fully served his prison sentence, but that doesn't mean that he doesn't want his unconstitutional conviction vacated.
No, I assume he does. But
yes.
It's also true that Mr. Betts has not served his
Right.
sentence?
Mr. Betts entered a conditional plea and then went to appeal the case to this point. So if this court were to deny leave, he would be sent to prison. Yeah.
Correct. Thank you.
Seeing no further questions, thank you.
Thank you, Counsel.
Good afternoon, Miriam Aukerman, ACLU of Michigan, as amicus. I appreciate the court allowing us to present argument today. I wanted to amend slightly what we said in our amicus brief in terms of the paths this court could take, because I think there are various paths this court could take, and we would ask that they sort of, whatever path you choose, meet sort of three basic principles. One is that it respects federal and state comity issues. The second is to avoid the inevitable chaos that would result if there were conflicting federal and state questions. And the third is that it be helpful in terms of this process that Mr. Restuccia was talking about that's underway with respect to reforming the statute. So those, whatever path you choose, should meet those criteria, I think. I see there as being sort of four basic paths the court could go down. One would be to deny leave and remand for consideration in light of Doe's 1 and to address the collateral estoppel issues. The second would be to decide that SORA is not punishment, thereby creating a conflict and chaos. The third would be to decide that SORA is punishment in accordance with the Sixth Circuit. And the fourth would be not to reach the ex post facto issue, but to decide the collateral estoppel issue. So those are sort of the four paths. And what I wanted to do was sort of talk through each of those paths and what the implications would be if the court went down one of those. So denying leave, as you know, that would allow the federal litigation to proceed, the legislative process to continue, and that was what we were advocating in our amicus brief. The second path would be for this court to decide that SORA is not punishment, basically to agree with the prosecutorial positions here, create this conflict. And as we've talked about, as Mr. Restuccia talked about, that is really a recipe for chaos, because what you have on the one hand, would you then have police officers making arrests that are valid under state law, but they would then be subject to Section 1983 liability. And as Ms. Nelson pointed out, that is actually happening now. I'm contacted frequently by attorneys who are representing people who are in state court who are being prosecuted for conduct that is protected.
Did the ACLU argue in the Doe's case?
Yes, we did, Your Honor.
Did you argue that if they decided a particular way, in fact, if they decided any way, that they would potentially be in chaos with the Michigan Supreme Court when it later visited the issue?
At that point, what we were arguing at that point was that I was obviously in that litigation. I think this court is co-equal. I agree absolutely with Mr. Restuccia, and I think that if, for example, the severability issues come before Judge Cleland, as they might, it would be absolutely appropriate for him to certify those to this court for resolution. So I think, but the point is that there is this, I think that really more salient question is that the one is a class action. The Doe's 2 case is a class action, and so, as Mr. Restuccia pointed out, we have 2 individual appeals before you, but we also have a certified class in federal court. So I think that in some ways is actually the more important point, is that we have a certified class.
Ms. Aukerman, in your brief you said, at one point you said we should deny leave, and at one point you said we should reverse and remand. If we deny leave, Mr. Betts goes to prison. Is that your position? Is that appropriate?
I don't think that...
Possibly on an unconstitutional conviction. Is that...
No, I mean, we would, in terms of that path, I think the path would be to reverse and remand rather than to deny leave, or, to remand for reconsideration in light of Doe's 2 and in light of the collateral estoppel issues, I guess would be the path of this court not...
Of not doing anything right now. How do you like Mr. Restuccia's counteroffer?
In terms of... I'm sorry.
Granting leave.
Granted, so I think actually there's a real path. There is a path there. I would lay it out a little bit differently. I think that the court could, if the court wants to, it could decide the ex post facto issue and then set briefing for the severability issue and the collateral estoppel issue, or it could set briefing on severability and collateral estoppel, for example, down the road. I do think that there is a path that. I would agree with Mr. Restuccia that, it has been since November 2017. There is some progress legislatively, but I think if this court wants to weigh in, that could help. If this court issued a decision saying there is an ex post facto violation, but we're not deciding severability, we're setting a briefing schedule for severability, that would certainly move the legislature forward because it would make very clear that the legislature has a window within which to act. And just to be clear about the severability issues, the 2011 amendments, which the federal court said that retroactive application of those must cease, as you know, those are baked into the statute. And you have in our brief a copy of that statute, with all of those marked. The statute looks like Swiss cheese if you cut out the 2011 amendments. So I really don't think there's a way, if you reach the severability analysis, that you don't essentially void the statute for everyone before 2011. And I think that is, if you do reach the merits, I would strongly encourage the court not to reach severability quite yet for 2 reasons. One is there needs to be further briefing on it, although I do think that there's really only one conclusion that you'll reach on it. But I think the more practical political reason is that if suddenly, 20,000, 30,000 people come off the registry entirely, that is not going to be conducive to the kind of evidence-based process that we're involved in now. There's a call scheduled this week between data people at the state police and the Department of Corrections and researchers at the University of Michigan to analyze Michigan data to really try to have this driven in a legislative, really evidence-based way. We'd like to see that process work, but I will concede it has been some time. Intervention from this court could be very helpful in moving this forward. I also, in working on this case and talking to my colleagues at SATO, I do think if this court were to rule an ex post facto at this point and find that it is punishment, that would protect registrants who are currently facing criminal prosecution in state court because while these legislative negotiations are going on. So there certainly is, that is a path the court could choose to take that we would think could be helpful in moving things forward. Obviously, if the court were to reach the ex post facto and issue a decision that is counter to what the Sixth Circuit said, that creates a lot of complexity and difficulty, comedy issues, and creates a lot of confusion both for law enforcement and for registrants. The collateral estoppel issue, I think there the important point is that the issue with collateral estoppel is that the point is there are two basic purposes. One is to conserve judicial resources to prevent relitigation of the same issues. And of course, here we are relitigating the same issues. And there are dozens of cases in both federal and state court, in criminal and civil proceedings, relitigating the question of whether SORA is punishment. And we attached a partial list of those to our brief. So resources was not currently being conserved. It's also to prevent inconsistent judgments. What everyone needs is finality, as Mr. Restuccia said, finality and clear rules, and we won't have that if there are inconsistent judgments, but that's part of the point of collateral estoppel. It's not so much federal and state, it's the fact that the state of Michigan was a litigant here. It had a full and fair opportunity to litigate this issue. This litigation went on for years. There was an extensive record. The joint stipulated statement of facts was almost 300 pages long. It went up to the Supreme Court. They sought cert. It was denied. It does not get much fuller, much fairer, or much more final than that. And the final is important because the collateral estoppel is about who gets the final judgment first. The first final judgment here was in Doe's. It wasn't in these prosecutions because we're here today. These judgments are not final because we're here. And I'd point out that when you look at how these cases are captioned, it's people of the state of Michigan that's people of the state of Michigan v. Snyder. It is the people who are here. It is the state of Michigan that is relitigating this question. And they are bound, we believe, by the prior litigation that they engaged in and lost in Doe's 1. And so the collateral estoppel is, I think, a really important path that this court could take to say, even if you completely disagree with Judge Batchelder, you think, she got it all wrong. The state went through that litigation and it lost. There was a judgment that was issued after a full and fair opportunity to litigate, and that judgment should be binding on the state of Michigan here. So that is another path that the court could take.
Thank you, counsel.
Thank you.
The case will be submitted. And that concludes the call for today. We'll be back tomorrow morning at 9:30.